So what do you do first if you're served with a TCPA lawsuit? How do you respond? First and foremost, contact your counsel. Your counsel can advise you in more detail about all sorts of components to your TCPA defense that we don't have time to get into today. Call your counsel. Figure out what your deadline is. If the case is filed in federal court, you normally only have 21 days to file a written answer in court using local counsel, or you might go into default. After calling your counsel and figuring out what your deadline is and calendaring that, preserve everything. You're required to preserve and not dump or destroy, as part of your normal document destruction policy or otherwise, any relevant evidence, anything that could become relevant to either side in the case. So this would include call logs. This could include call recordings, scripting, communications, internal and with vendors about the campaign, dialer manuals, anything that relates in any way to the campaign or the individual call, the individual plaintiff, needs to be saved. If you know there's a legal issue or problem or claim, and then you don't identify and save evidence, if you delete something, for example, they call that spoliation. You can actually be held liable. You can be fined or otherwise sanctioned for destroying relevant evidence. So talk to your lawyer, preserve everything, and then prepare your defenses. A lot of plaintiffs, whether they have lawyers or not, agree to an initial extension, especially if you're willing to volunteer some information early on, or perhaps talk about settlement if you think there's a good reason to. But don't be overwhelmed. Hundreds of businesses every year in the United States successfully defend TCPA lawsuits. Sometimes you fight and win, sometimes you fight and lose, sometimes you settle somewhere along the way. Less than 1% of TCPA cases make it to trial. Almost all of them get dropped or settled somewhere along the way, and everybody learns from it and beefs up their compliance, and then you move on.